Thiru M.K. Stalin, Honorable Chief Minister, Honorable Members of the Council of Ministers, my colleague, friends, Mr. Dwivedi, Mr. Wilson, the Advocate General, rightly referred to as the soul and voice and Atma of many issues and of journalism, my good friend Mr. Ram, distinguished members of the legal fraternity, members of this distinguished audience, ladies and gentlemen, Vanakkam. I was thinking that when the Sengol was handed to us, the real person who deserves the Sengol is the Chief Minister. We have done a partial disservice in not presenting him with a Sengol because Sengol represents righteousness and he has upheld the righteousness inherent in the ethos of a state like Tamil Nadu, which has flown for longest and consistently, irrespective in fact of political color, has flown for longest and especially through Periyar and Anna and Kalaniyar, the flag of federalism. Wilson did me the kindness of telling me just 3 minutes before that we have to speak also. He didn't realize that a lecture had been fixed in the afternoon today on federalism before the judgment. And it is a strange coincidence that the date of the lecture has happened after the judgment. So despite his extremely short notice, my lecture was on federalism today to a large gathering of lawyers associated with the DMK party and the Congress party. So let me tell you a few interesting facets and facts about that theme before we come to the particularized issue of governors. The particularized issue in this judgment is governors. But that is in the setting of federalism. So the first aspect, I won't take very long, but it will take a few minutes because this is far too important a theme, and a theme on which the DMK and the Honorable Chief Minister have been at the very forefront. And some of them will find it interesting that the first contextual setting of federalism arises from the fact that India is planet Earth's most diverse spot. There is no more diverse spot in the world as planet Earth, with hundreds and thousands of languages, dialects, diversity of smell, food, diet, ritual, the birthplace of 4 religions on planet Earth, the largest number of 2 other religions, or the second largest number of 2 other religions. It's completely a bewildering array of diversity, to which federalism belongs more than anywhere else. Where else will you have the concept of federalism, except in as diverse a spot as India? The second aspect is that India did adopt a top-down federal structure, unlike other countries which are truly federal. For example, many states in the US were pre-existing countries who ceded their sovereignty, gave up their sovereignty to form the United States of America. That was bottom-up federalism. So today you have separate citizenship of states of USA. You have separate flags. We had top-down federalism, but we nevertheless have a concept of federalism. Now, there is no doubt that when our wise founding fathers sat for 3 years in the assembly, Constituent Assembly, the thought uppermost in their mind was the fissiparous tendencies which they were seeing. They were scared that India would not survive this horrific partition, the cruelties and the migrations. So they clearly, in design and conception, created largely a unitary constitution. There is no denying that. In design, conception and inception, it was a largely unitary constitution, which is what led a well-known Australian, Kenneth Weir, to later comment upon it and say that this is actually a quasi-federal country. He coined the phrase quasi-federal. And the Supreme Court later called it amphibious, basically unitary with some federal features. But the real point I wish to make is not that. The real point is the astonishing and remarkable paradox and story how in 75 years, in actual operational reality, India has become much, much more federal than in design, in inception in 1950. This has been called, very interestingly by scholars, accidental federalism or inadvertent federalism. But that is now entrenched. And today in the morning, I identified 6 federating influences over the last 75 years, which have made this a overall much more federal culture. The first of that was linguistic federalism, which happened in the 50s, creation of states along linguistic lines, a recognition of identities. Federalism in India is more about identities than about interests. The second was rapid, prompt, vigorous judicial review, so that the use or misuse of Article 356 has diminished considerably in the last 2 or 3 decades. There are only about 15 or odd examples. I've had the privilege of being in many of them. And this way or that way, from Uttarakhand to Jharkhand to Karnataka twice to Maharashtra to so many other states, the intervention by courts is swift, prompt and vigorous. Unlike when poor Mr. Ramakrishna Hegde lost his place in Karnataka, he filed a petition. He got relief after 3 years or 3 or 4 years, by which time governments had changed twice. So he won the principle and received no relief in practice. Classic case of operation successful, patient dies. That is not the case now, which is why the anti-federal 356 is much, much, much in check. The third influence, the single most biggest quantitative influence, is Panchayati Raj and municipal self-governance. Because another synonym for federalism is decentralization. That has happened as late as the 73rd and 74th Amendments in the 90s. So clearly, you have an army out there. When I as an MP go to my home state Rajasthan or to West Bengal, now from Telangana, sitting across is an elected representative of the Panchayat and more often than not a woman. Some 20 lakh elected women, some 35, 40 lakh total people. This is decentralization, federalism at its best, a third tier of government. And similarly, municipal self-governance. So this was the third aspect of inadvertent federalism in operational reality. The fourth was the liberalization of the 1985s and the 1991 in particular, where the power of the central government and the central ministries considerably diminished. I always like to joke, and Thiru M.K. Stalin should be happy to hear this joke, that a chief minister of any state in India, and certainly of Tamilnadu, is at least 3 times as more powerful as a cabinet minister at the center. Though both of them occupy the same level in the protocol, in the warrant of precedence. Why? Because you don't need to go to the central government anymore for many things. That is another form of federalism. The fifth was the entrenchment of regional parties. Prior to 1991, it had never happened as an organic evolutionary path. Since 1991, regional parties have been entrenched and embedded in Indian politics across the length and breadth of India, and in many times after 91, larger parts of the territory of India have been governed by regional colors than by either national parties, whether Congress or BJP. Large territories, sometimes 60%. This again was part of unintended, inadvertent federalism. And then again, there was fiscal federalism, which of course has been assaulted very majorly in the last few years. But no doubt, as compared to the time when the Constitution was created, when we devolved funds approximating 30-odd%, we now devolve 41, 42-odd% funds to the states. So there has been a degree of fiscal federalism over the last 75 years. Now, having seen these developments of very cherished, desirable, operational, even though inadvertent federalism, we must turn to how, totally against the spirit of what has happened in 75, and in many cases totally against constitutional text and context, the clock is intended to be set back on federalism. Before I come to governors, take the example of fiscal federalism. I'll give you two striking examples. I'm sure chief ministers like him have many more examples in their pocket because they are the sufferers. When the GST came in 2017, an act was passed acknowledging and recognizing that states will lose revenue because GST regime will take some time to stabilize. It was decided on an ad hoc basis, no doubt, that that stabilization will take 5 years, from 2017 to 22. And therefore, for that period, a cess stabilization fund was created, whereby the shortfall incurred by states would be returned to the states by the center to compensate them for what was said to be the adverse effect of GST. This is pure federalism because actually the enactment of Article 246A itself is seen by many as an assault on federalism. The states had ceded their rights, given up their rights to collect many taxes, to put them into one hodgepodge and one pool of GST, and hence this compensatory scheme. Well, by 2020 or 21, both before and after COVID, it turned out that the total aggregate shortfall of funds due to all the states on the GST account, the shortfall, was 2,35,000 crores. 2,35,000 crores. The central government scrambled, scrounged around and produced 97,000 crores. And then, and this is what I wanted to emphasize about fiscal federalism, in a cruel twist of fate and with one stroke of the pen said, 2,35,000 crores minus 97,000 crores, namely whatever 150 or 140 or lakh odd crores, is written off as an act of God. So an act of God, a force majeure was mounted upon federalism without any attempt to repay in future progressive installments that which was owed to the states. Even a worse example of assaults on fiscal federalism, because this is a setting, it's a much larger setting than merely governors. This is a much larger setting of federalism. Is a little noticed article, Article 293 of the Constitution, which was created as part of our unitary structure to say that a state government cannot borrow without central government permission. That is in the Constitution itself, no problem. But that has been whittled down by government, this central government, by saying that when first we will find your eligibility to borrow. There is a parameter set down that you can be eligible to borrow on various parameters of how you control your fiscal deficit, etc. So Tamilnadu is allowed or eligible to borrow 100. But we will include in this that which your PSUs have borrowed, which the state has not borrowed. So by adding PSU borrowing, you diminish that borrowing capacity considerably. By such states of hand, you weaken states. There have been public complaints, and Kerala in this respect, which by the way has managed its fiscal deficit remarkably well, has filed a petition in the Supreme Court saying that 293 cannot allow a whittling down of the power of the state to borrow. They are also sovereign entities, and remember, the 15th Finance Commission discussed this issue, but nowhere suggested that that which the state PSUs borrow should be included in the state's account. But the central government did it, despite the 15th Finance Commission not saying so. And that matter, hopefully, the Supreme Court with regard to federalism will take some interest. Turning now, of course, to the most topical, the issue of governors. We can look at it from three bases. The first basis is the Constituent Assembly debates. I would urge all of you, or most of you, to go back to the Constituent Assembly debates and read all, leave aside Baba Sahib, but even all the others on this subject. And all of them are saying thematically 2 or 3 fundamental things, which all our masters or agents of the central government seem to have forgotten. Indeed, they seem to have forgotten there's a book called the Constitution. First thing they said was that there cannot be diarchy. The word used in this Constitutional Assembly debates is diarchy. There can't be 2 swords in one scabbard. एक म्यान में 2 तलवार नहीं. The meaning of this is obvious. There are no 2 chief ministers. There are no 2 elected bodies. And there is no one super chief minister sitting over another elected chief minister. Second, they said, therefore, we will nominate him. The governor, not elect him, as Mr. Dwivedi said. But then Dr. Ambedkar added a very interesting paragraph. He said, I look at governors to be purely ornamental. The word ornamental is Baba Sahib's. And I believe that the governors are so powerless, they have virtually no powers, that we will find it difficult to find people to nominate. I can understand why many of these wise old gentlemen will be turning over in their graves, seeing what governors, not in Tamil Nadu alone, Tamil Nadu is the third, starting from West Bengal and travelling to Punjab, and then Tamil Nadu is happening. So it is crystal clear that the debates did not envisage a governor, except in the rare cases of minority governments, dissolution, or maybe a report to be sent under 356, which are very special sui generis. In no manner. If it is so clear, then you look at the case law. Forget the recent case law. When was 7 judges sat way back in 74 in Shamsher Singh? Shamsher Singh says the same thing. If the governors, especially in some states, don't read, we must put some readers in their offices. It says very specifically that the powers are limited, they are nominal, they are titular, they must be bound and act only on the aid and advice. So really what is now done by this judgment in fundamental principle is not new in that sense. It is the implementation of that principle to the last mile connectivity on a new set of aberrations. The principles are well established 50 years ago. Then comes, between the Constituent Assembly debates and the judgments, mega reports like the Sarkaria Commission, the Punchi Commission. They reiterate the sentiment of the Constituent Assembly, and they go further and say that even on matters where the governor sends routine reports to the central government, he must consult the chief minister. The whole idea is that he should have a very harmonious, interactive relationship. The role as an obstructionist, the role as a conspirator, the role as a negative element in the process of governance could not even have been dreamt by these wise men in any manner. Well, having said that, this scourge, and we should put it bluntly, this scourge has started only after 2014. Palkiwala said that unless you are honest, candid and blunt with words, words have to be an assault on the senses for reform to happen. Why does it happen only in opposition-ruled states? There are governors in all states. Have you ever found a governor of the same political color acting or behaving even 1/100th in the manner certain governors in certain states behave? And did the eminence Greases, whose comments we hear left, right and centre every day, from the new law which we are taught that Parliament is supreme, to the other law which we are taught that Supreme Court is overreaching itself, I want to ask a simple question. Did any of them ever comment when the bills of any state were held up for 2 years, for 1.5 years? Did any of these constitutional functionaries ask that question, how can a bill be held up for 2 years or 1.5 years? The very same persons who are today telling us that Parliament is supreme, the Constitution is not supreme, that the Supreme Court has overreached as the sole custodian and interpreter of the Constitution. You know, right or wrong, our framers put the final power of interpretation of that which is supreme. The judiciary is not supreme, executive is not supreme, legislature is not supreme. Only the Constitution is. But the final interpretation of that which is supreme is put by Article 145 on 5 wise men of the Supreme Court. Article 145 says so. So, good, bad or indifferent, if the Constitution designates an institution as the final interpreter of the temple of justice, as the priest at the entrance of that temple, then well, jolly well you have to go by that interpretation, not yours. Now the pattern is interesting, and I must ask you to rewind a little bit before Tamilnadu. I had the privilege of moving the first petition for West Bengal, where similar 9, 10, 12 bills pending, of course not as long as Tamilnadu, nowhere near as long as Tamilnadu. And the pattern was very similar. When the bills accumulated, and it came in the press that the government of West Bengal has filed and is about to move in the Supreme Court. Before the date when the matter is listed in the Supreme Court, the Honorable Governor passes 1 or 2 bills. He gives assent to 1 or 2, just before the date is coming. And thereafter, time is taken for further arguments and replies. The balance 6, 7 bills are kept back. And then finally 2 more are passed. And then they are either referred to the President or kept pending. That disease travelled from West Bengal to Punjab. And I happened to appear for the state of Punjab as well, where in a judgment, the core issue was twofold. One, that the governor actually argued that he is not bound to give assent. So Chief Justice Chandrachud's bench, speaking through the then Chief Justice Chandrachud, clarified and clearly said that part. The second part was a peculiar part, which did arise in Tamil Nadu. The governor also refused to allow an assembly to be convened to pass and repass bills. So that was completely stigmatized by the Supreme Court, saying he has no power. The Council of Ministers can convene and the governor cannot obstruct, because that is also part of the process of passing bills. The governor of Punjab went one step further. You couldn't convene the assembly, so you couldn't pass any bills anyway. So that was a definitive judgment, but 2 or 3 issues did arise there directly. 1, time limits. 2, presidential reference. 3, President of India. These 3 issues did not arise there. And then along came the Tamil Nadu case. Now in the Tamil Nadu case, before people start shooting their mouth and be on a go-lucky, happy trigger basis, they should realize the painstaking, nitty-gritty detail in which that hearing was conducted. Not once but twice, in a quite unprecedented manner, the bench delved deep and made issues and notes on diverse issues, burning the midnight oil, and we publicly complimented the set of young law clerks who did that, and then gave those notes to us and to the Attorney General, saying these are the collateral or the direct or the ancillary or the related questions which arise. Please give us your views. Please help us. Not once but twice. Time was taken by the Attorney General as by us, and we both submitted submissions, detailed submissions. The matter went on over several weeks. There was careful consideration. There was in-depth consideration. There was meticulous attention to detail. Where is the question of some kind of a casual, hurried exercise? And on the 3 or 4 points which it held, I would challenge anybody to tell me any cold, logical reason except a biased, preconceived notion as to why there is a judicial error or judicial overreach, including in the references to the President of India. First, it clearly reiterated the binding nature of what the governor receives. Second, it reiterated that on a second sending by the state, the governor loses whatever little discretion he has on the first return basis. Third, the dates made it clear that the governor found nothing wrong as far as conflict in the concurrent list or unconstitutionality is concerned when the bills first came to the governor. Then how on earth, on the second reference by the state government, did he refer it to the president? Fourthly, it is laughable that the bills were entirely domestic list 2 issues. There could be no conflict with the central law. Even a first-year law student will tell you that that could not have been referred to the president because there was no conflict with any central law. They were pure list 2 issues. Finally, the court came to the point that you cannot have all these nice, large rights without a remedy. You cannot have the rhetoric of noble thoughts and unreal expectations without an actionable methodology by which to achieve it. So after much consideration, and here the court went beyond the normal rules to look at a global survey of all other countries, and then came up with 1 or 3 months. What is wrong in that? It doesn't mean that every time a bill comes to the governor, the court has said there will be deemed assent. The court has never said that. This is being touted in the press as if now they're all deemed assent. But if a bill from list 2 comes, and Mr. Dwivedi talked about 1 week, 2 days, 5 days, if a list 2 bill which on the face of it is not conflicting with anything, on what basis can the governor say that 3 months is too short? And if a bill comes for the presidential assent, why can't he see it there and there and refer it to president? Nothing stops that. Now the presidential part. Obviously, in the case of the president, there is no reference to a further president. Otherwise, the article is identical for a governor and a president, which people are forgetting. People are blaming the judgment that the president's case did not fall for consideration, but an interpretation of the clauses of the governor would apply mutatis mutandis to the president. Because in terms of a bind, of course, I can tell you in a lighter vein that this will never arise in a normal central government versus president situation as far as the current government is concerned. I'd like to see that happening. But the point of the matter is that the same principle of 1 month or 3 months must apply to the president because the textual nature of the constitution is no different at all in any manner. In fact, the Supreme Court would be inconsistent if it applied one different interpretation for the governor and a different interpretation for the president. Then, the sixth aspect, that you are laying down time limits which are not there in the Constitution. Somebody should see the jurisprudence of this country in the last 20, 30, 40 years. Most of the seminal judgments have operated on the basis of laying down principles in what is called the unoccupied areas of the law, in the unoccupied interstices of the Constitution and statutory law. I'll give you one striking example which all workplace persons here will know, Vishaka, sexual harassment at the workplace. Completely in the unoccupied interstices where there is no inhibition by law, where there is no constitutional inhibition, there is no restraint on the court putting something as minor as a time limit to effectuate the right, which would become remediless without that effectuation. There are innumerable other cases. Vishaka is one example. So this is again ill-informed, petty and motivated criticism. Well, friends, as I come to the end of this, I want to say that ultimately federalism is what federalism does. Federalism is all about spirit. There is this amazing paradox of the Indian Constitution and Indian jurisprudence, which we must cherish. If any of you Googles the Constitution, which by the way when it was made was one of the second or third longest constitutions in the world, and even today is amongst the longest. In the longest constitution, or one of the longest constitutions of the world, there is no word called federalism or federal. It's not there in the preamble, it's not there in the entire constitution. You will come across the word federal in several articles, but that's not the federal we are talking about. The federal there is a reference to the precursor of the Supreme Court, the Federal Court. Now, the amazing and cherishable paradox is that something not found in the preamble and something not part textually of the Constitution has been held repeatedly from Keshwananda onwards to be part of the basic structure of the Constitution. Federalism is an inherent part of the basic structure of the Constitution. Something, a status accorded only to 7, 8, 10 features. And that is not something which can be the plaything of temporary majorities. It cannot be the plaything of the vicissitudes of a particular viewpoint which the center has over states which have a different political color. The true spirit of federalism, which was supposed to contain dissatisfaction, dissent at the local level, it is a very valuable safety valve, like a pressure cooker, to prevent explosions at the center for everything. It quarantines conflicts at local decentralized levels. The main thing about it is to operate it in principle. To operate it in spirit, not merely in principle. Nobody in the Constituent Assembly or thereafter could imagine that every time there is a different political color, just because regional parties have sprung up in this country after 1991, you will violate every aspect of federalism, and the examples mushroom every day. They are born diverse, new every week. From unwanted, uninvited dinner guests to non-dinner parties like the CBI, which enters different states. And it is to our credit that we passed a section which said a recognition of federalism, that the CBI can't be an uninvited guest in a dinner party held by the Chief Minister of a state. And yet, every day we do bizarre cases. Bizarre is a mild word, where the CBI claims jurisdiction. And mind you, the CBI can always come under two well-known exceptions by the High Court and the Supreme Court. Political vendetta, the use and the misuse of the biggest allies, be it the IT or the ED or the CBI. When you ask the ED, and I've had the privilege of doing this in many cases, when you ask the ED, they give out a very interesting figure. They say that cases with a political color are only 4-5%, which is actually true. Which is actually true. But if you ask them the second question, they fall silent. Out of those 4 or 5%, how many cases involve coercive steps against non-ruling party leaders? The answer is 95%. That is another facet of coercive federalism. All the rhetoric about cooperative federalism, competitive federalism, is only rhetoric. The reality is coercive federalism. From the CBI, from the vendetta politics, from the issues of fiscal stepmotherly treatment, from the role of governors, I'm not talking of any particular governor, who are not agents but supposed to be acting as supari agents, efficient supari agents. These are antithetical to the heart and soul of something which is elevated to the status of the basic structure. Therefore, it is not a question of the battle and the war and the candlelight and the torch which Stalin, the Chief Minister of Tamilnadu, has started. It is a matter for every state. It is a matter for every state to think. Because every state has to remember that saying. First they came for the Jews, I kept quiet. Then they came for the Philistines, I kept quiet. Then they came for the Christians, I kept quiet. Then they came for me, and there was nobody to speak for me. So when he speaks for you, all others must join him. Thank you very much.